Note details of the opponent's general appearance, mood, or any noteworthy actions. It was noted that the opponent is confident, made good direct eye contact. He wore a blue medical face mask, long sleeve navy blue, light blue front top, Impala emblem, track suit jacket, and a blue denim. Both his hands were cuffed in front of him.
Just net 'n oombliekie. Dan is die gedeelte wat my geleerde vriend versoek het dat dit nie op rekord geplaas moet word.
That's now, just a moment, that's the part that my colleague requested record.
Okay, kan voortgaan, skus.
Both hands cuffed in front of him, cuffs loose, not tight. No visible marks on face or hands.
Lana ke kusechazwa ke okanye noma ke umuntu owaletha ke yena wamletha ke kuoffice lami uyena uSergeant Vusumuzi Mukhane othi owayichaza ke nokuthi ke ubuya ke National Cold Case Investigation Unit ePretoria chazwa ke lana indlela awayibukeka engayo noma engambona engayo ke phambi kwami ukuthi ubonakala nje enokuzethemba futhi ke nokuthi nokubhekana ke ngamehlo ke kwangasi umuntu ke owabalekisayo amehlo kwakune eye contact ke efake ke im face noma ke i mask la ebusweni eyayi blue ngombala egqoke i long sleeve e navy blue i light blue i top ngaphambili ene emblem ke ye Impala i track suit jacket kanye ke ne denim e blue zombili ke izandla zakhe ifakwe ozankosi phambi kwakhe ke kodwa ama cuffs aye loose ayengekho tight.
Hier ek sien dis amper 25 uur 11 is dit 'n dienstige tyd om die kort verdagging te neem op hierdie stadium.
Is verdacht tot watter tyd?
15 minute.
15 minutes.
15 minute is verdacht.
As a court pleases, my lord, as I mentioned at the inception of the proceedings, there is a recording of this interview, and I've received it this morning. It was mentioned to me previously, but I received it this morning. I've given it to the defense, and at this stage, the view is that we proceed with the evidence, and after her evidence, they will then go and listen to the recording overnight. But I think there's one dissent regarding that suggestion, and yeah, I just don't know how we're going to handle that. But the suggestion is that we proceed, and before cross-examination, they will then go and listen to the recording. That's the majority view.
But then the court must have sight of that.
Well, the problem is this, my lord, that some of the things that appear in the recording have been redacted, and those are the portions that should not be heard at this stage. So it will then not be possible to make a copy of everything. I think that's why the state doesn't even want to use that. I think at best it can be, and it also contains the statement itself, which at this stage, my lord, is inadmissible as it must still be proven.
Yeah, so. Fine, I hear you. But if it is quoted or referred to or cited in any of the arguments, this court has to listen or see it. How do I arrive at a finding, whichever way?
Yes.
When half the evidence is not before me.
Yes.
So it's either it's used or it's not used. But if it is used, the law is clear.
Yes, that's. We agree on DESCO. Hence, we do not want to use it at this point. But my colleagues apparently want to decide whether they are going to use it or not.
No, fine. Okay, let's go on.
But as I say, the suggestion is that we proceed, and at the later stage, they'll then make a...
So when you say at a later stage, Mrs. Kronje is not going to be cross-examined. If she finishes the evidence today.
No, not today, my lord. We have just checked her availability tomorrow. She did indicate that she can avail herself
Is that so?
tomorrow. Yes.
Okay. Is that true?
That's correct.
That's correct.
All right, fine. Yes, let's go.
By the state that the witness should actually complete and finalize the examination in chief. The matter then is stood down until tomorrow morning
Stood down for what?
to continue the cross-examination of the witness.
Yeah, fine. As long as it will begin
That's correct.
at some stage.
Court.
Okay.
As the court basis, my lord, I have an objection, my lord, to that, because the information that the state has just disclosed now, my lord, it's related to the evidence of the witness who is currently testifying, and that information, my lord,
Related to the witness who?
who is testifying.
Yeah, fine.
Yes, my lord. That information, we have not been given the opportunity to listen to it. It has just been disclosed to us, my lord, now during break. Therefore, my reasons for objection, my lord, is that it is crucial to listen to that portion of evidence before this witness testifies.
But this
As-
witness is in the middle of a testimony.
The state decided to disclose a new evidence in the middle of the testimony, my lord.
No, but if I understand Mr. Baloyi, he says he initially did not intend to use that evidence. Am I quoting you correctly, sir?
Indeed, my lord. It was just
Listen when people talk.
for the purpose of being open and transparent
Yeah,
to the
when it
defense.
tells you we've heard this.
My lord, the state may not be intending to use it, but as a defense also once it has been mentioned that the evidence is available.
We're entitled to it.
We're entitled at least to listen to it, my lord, so that we can be able to proper instructions whether we are on the same page with the
No,
state,
fine, I don't have a problem with it.
that we won't be using it because
We are
maybe
entitled to it because
Yes.
in terms of the case of State versus Shabalala, any information which is in the docket of the state, is it accepts A, B?
yes.
Hello? Is it sections A and B?
Yes.
The other
Sections A.
information should be made available.
Yeah, B and C. In
Yeah,
fact,
sorry,
yeah.
the other way around.
Yes. And this one is part A, my lord.
Yeah, fine.
Yes.
So you may use it anyhow you want it. But all I'm saying is if it's used, it must form part of the record, obviously.
Because you may find out that the defense will be using it, my lord.
Yeah,
Yes.
no problem.
Yes.
Okay.
So I'm asking for that opportunity to listen to this video now, my lord.
No. This witness is still under oath and she's testifying.
Yes.
She'll testify, finish her testimony, prepared to stand down, a cross-examination, then you can listen to whatever video or opname you want to listen to. Then Ms. Kronje comes and she's cross-examined by all of you. No problem.
No, it's fine, my lord, if the order is coming from the court that I cannot listen to that video until this witness finishes.
I never said that.
Oh.
I never said that.
My apologies, my
I
lord.
never said that.
My apologies, my lord.
I say you're entitled to that video.
Yes, my lord.
Yes.
Yes.
In terms of State versus Shabalala, you're entitled to it. He can't hide it away from you. But he can decide not to use it, like he says he intended not to use it. Fine.
Yes.
But this witness has been sworn in. He's in the middle of a cross-examination, of evidence. Let her finish. And thereafter, we stand down her cross-examination. In the meantime, anybody who wants to listen to the video or the recording can do so. So that when the cross-examination starts, we are fortified with the information in the video and everything. What's the problem there?
My lord, my request was that I'm asking for an opportunity to listen to this video now, my lord.
Now.
Yes, my lord.
And then this witness,
This witness can stand down.
until when?
Maybe until 2 o'clock, I think we'll be done with that video.
No, application is refused.
As the court business.
Just continue, Mr. Baloyi.
Please, I can also mention that the recording is 3 hours long.
That video is what?
The recording is 3 hours.
3 hours long.
Yes.
God.
Ngaphambi kokuthi umshushusi aqale-ke udaba lana lumayelana nale recording umshushusi bekakhuluma ngayo ngaphambilini ethi-ke unikezile abameli ngokukhulumisana-ke abameli bayacela-ke ukuthi banikezwe ithuba-ke lokuthi bayilalele ukuthi-ke ufakazi abanye abameli bathi ufakazi angaqhubeka uma umbuso usuqedile-ke ngaye banikezwe ithuba bahambe bayolalela base bayabuya-ke bambuze imibuzo umeli-ke ka-Chiefs number 5 yena kuyacela-ke ukuthi cha ufakazi angaqhubeki-ke manje alalele noma abukeke leyo video noma leyo recording leyo abe uma seqedile-ke abuyeke ufakazi-ke noma ngo-2 kodwa-ke inkantolo ithi cha akaqhubeke-ke nanjengoba abanye abameli beshila ukuthi angaqhubeka mase kufika ithuba labo ukuthi babuze imibuzo bangabuzi kodwa bahambe bayolalela leyo recording leyo ngoba uthi umshushisi ithatha amahora awu-3 leyo recording.
Mevrouw Cronje, net voor die kortverdagging, ons was bij die gedeelte waar u die voorkomst van die deposant zijn gemoedstoestand op record geplaatst hebt. U kan voortgaan waar u opgehouden hebt.
Just before the short adjournment, we were on the part where you were now describing the appearance of the deponent as well as his condition. You can proceed from there.
Ek het aan die deposant gevra of hy enige mediese toestande of beserings wou rapporteer waarop hy geantwoord het I do not know or I do not want to report it.
Okay. I then asked the deponent if he had any medical condition or any injuries that he would like to report, and then yes.
I do not want to report if any medical conditions or injuries except had a heart problem and I haven't taken a bath since 16 June 2020. Dit was sy antwoord gewees.
That was his response. Lana-ke uphendulile-ke wathi uma ebuzwa ngokuthi unokulimala noma unaso yini isimo-ke esimhluphayo ngokwezempilo wathi-ke akukho-ke engifuna ukusho-ke mayelana nezempilo noma-ke ukulimala ngaphandle nje ngokuthi-ke nganginenkinga-ke yezenhliziyo angikaze futhi-ke ngigezeke noma-ke ngithathe ibath ukusukela ngazo i-16 zikaJune 2020.
I informed the deponent that I am a magistrate and that I am not in any way involved in the investigation against him, that I do not work with the police or any other person in this case, and that he can speak freely and without fear in my presence.
Ngase ngimazisa-ke ngimtshela-ke ukuthi ngiwumantshi ukuthi-ke ayikho-ke indlela-ke engibandakanyeka ngayo-ke kuphenyo-ke lwalo noma kuphenyo ngakuyena nokuthi futhi angisebenzisani namaphoyisa noma-ke nawuphi-ke umuntu okuleli cala leli nokuthi-ke angakhuluma ngokukhululekile futhi angesabi ngikhona.
He was also informed that if necessary, he will be afforded protection against any irregularities and that I will as soon as possible have any irregularities investigated by a senior police official.
Ngase ngimazisa-ke noma watshelwa-ke ukuthi uma ngabe isidingo sikhona-ke ukuthi uzonikezwa-ke ukuvikeleka noma-ke uzovikelwa-ke uma kukhona nje okungahambi ngendlela noma-ke okungahambi kahle nokuthi-ke uma nje kutholakala-ke ukutholakala ukuthi kukhona nje okungahambi noma okungenziwa kahle ngizokhulumisana-ke nephoyisa-ke phezulu-ke ngesikhundla ukuthi alikuphenye lokho.
That this is not a trial and that I am not hearing any charge against him.
Nokuthi futhi lokhu-ke akusikona ukuqulwa kwecala nokuthi-ke angizanga lana noma-ke angikho lapho ukuthi-ke ngizolalela-ke ukuthweswa kwakhe icala.
He was asked, do you understand this explanation and do you accept it as correct? And his answer was yes.
Ngambuza-ke ukuthi uyakuzwisisa yini lokhu engichazayo nokuthi-ke uyakwamukela ukuthi ku-right yini noma kukahle. Impendulo yakhe yabe isithi-ke yebo.
He was then asked, do you wish to comment or have anything to say in this regard?
Wasebuzwa-ke ingaba kukhona yini ofisa ukuthi ukuphawule noma-ke into ongayisho mayela nalokhu.
As a court, please, my lord, during the short adjournment, we further redacted the document, and amongst others is the answer that follows. I'll just beg leave to hand up this document that we further redacted. We made copies for all counsel.
Uyasho kumshushisi ukuthi ngaphambilini bekushiwo ke ukuthi sikhona ke izinto lezi ezisusiweke noma ezisuliweke enye yazo ke ilena impendulo ke bezonikezwa manje usunikezwa ke le copy lena ke umehluli lena lana ke le part lena aphendule khona ke isuliwe khona.
And amongst others is the whole answer that follows on that question.
Kanye futhi nayo yonke ke impendulo elandelayo kulo yombuzo loyo.
Mevrouw Kronjekaneki, from the antwoord oor te slaan.
Can I request you, Mrs. Cronje, just to skip the answer?
And
Does it appear the unveil now? Mr. Baloyi, are you saying the answer appears there?
on the redacted version.
On her.
Yeah, she's got the original, my lord, yes.
You didn't redact it.
No, the original, we can't redact it as it might be used perhaps at the later stage, yes.
And this redaction is with the
Yes.
consent of all the councils.
Yes, we
and
put our
yourself.
we-
It's not an individual
No.
frolic of yours,
No, we all put our heads together
right?
and each made their inputs.
So it's by consent, in
Yes,
other
it's
words.
by consent. And we've made copies of such redacted version
Yeah.
of the statement.
Okay.
Lokhu ke futhi okusuliwe ke ukuvumelana ke phakathi komshushisi kanye nabo bonke ke abameli bavumeleneke ukuthi ke yini ke le ekufanele ukuthi ke isuke ngamanye amagama kuma kufundwa manje ingaveli ke manje ukuthi impendulo waphendula wathini.
Ik kan gaan naar paragraaf 2.
Can go to paragraph 2.
Question was asked, who brought you to my office and for what reason? His answer,
Umbuzo wase uthi ke umbuzo ubani owakuletha ehhovisi lami futhi ekulethela siphi isizathu impendulo yakhe.
Kan ek dan vra om net te lees tot waar die sin eindig met officials.
Can I just request you to just read the answer where it goes up to the officials or officials.
Sergeant Mugane, who was escorted by the Metro Police officials.
Impendulo yasithi ke ngilethwe uSergeant Mukhane owayekhashwa ke amaphoyisa ke noma iMetro Police.
Then what follows thereafter, my lord, was also redacted. Kan ek vra om die sin te lees wat begin, the police told me.
Oh, okay.
The police told me to come to court to make a statement, and I also wanted to make a statement, and I am happy to make one.
Ya impendulo yakhe ke ithi amaphoyisa ke angitshela ukuthi ngize enkantolo ngizokwenza istatement. Nami ke ngiyafuna ukwenza istatement futhi ke ngenemeke futhi ngijabuleke futhi noma ngiyathokozela ke lokho.
Excuse net voor u voortgaan. As ek hier net kan terugneem na die vorige bladsy 1.
If I can take you back to the previous page, page 1.
Daar heel onder, daar staan magistrate, deponent, interpreter. Kan u net verduidelik waarvoor staan dit?
Right at the bottom there is magistrate, deponent and interpreter, and why is that there?
Hierdie is onderaan elke bladsy gebring in die proforma vorm sodat al die partye in mekaar se teenwoordigheid elke bladsy onderteken. En so het ek self dan as ook die deposant sy initials en die tolk ook haar initials aangebring op elke bladsy en die volle handtekeninge is dan aangebring op bladsy die bladsy is oorgenoem, bladsy 8.
It is brought, my lord, or it is there at the bottom of this of each page, wherein myself, the deponent, as well as the interpreter, initials, and then on page 8, the full signatures appear there on.
Hierdie aantekeninge en is eers aangebring nadat die hele konfessie gevat is en dit weer teruggetolk is en die deposant aangedui het dat hy tevrede is, waarna ons almal in mekaar se teenwoordigheid die handtekeninge op elke bladsy aangebring het soos aangedui is.
Now, these signatures on page 8, my lord, were then brought about after everything, or after the confession had been taken, after it was interpreted back to the deponent, after the deponent had indicated that he was satisfied with that which is contained, then each and every one of us then signed on this page. Sorry?
In each other's presence.
Or in each other's presence, and yeah.
Ja, goed, ik kan teruggaan naar waar ons opgehou het.
Can then go back.
Vraag 3 is nie aan hom gestel nie, aangesien dit nie van toepassing was in hierdie geval nie, en net betrekking het op 'n deposant wat minderjarig was, wat nie die geval was nie.
Question 3 was not put to him, saying that it was not applicable in this instance. It is only applicable to someone who is a minor. Page 3, sorry ke umbuzo wesithathu ke wona ke awubuzwanga ke wona ke ngoba ke umbuzo obuzwa kumuntu iminyaka yakhe noma ke oseneminyaka ke noma umuntu okufanele ukuthi amelwe umzali kodwa hayi umuntu osekhulile.
Ten spyte daarvan dat hy prokureur teenwoordig gehad het, het ek voortgegaan met vraag nommer 4 op bladsy 3.
As much as he had a lawyer, a legal representative present, I then went on and asked him question number 4, which is on page 3. Sorry, I just didn't interpret the previous with regards to the statement. Khona nje engikushiyelele ngaphambilini, lana ke ku page nganye ke la enzansi. Khona la kubhale khona magistrate lona ke futhi okwenza istatement kanye notolika lapha khona ke bengasayini kodwa nje bekubekwa ama initials kodwa ke uma esechaza ke uthi lapha ku page 8 yila khona ke kunama signature onke noma ke uma sithi ke onke ukhuluma awakhe akatolika kanye ke naloyo obenikeza ke ngestatement lokho kwenzeka emuva kokuthi ke i-confession isibhaliwe phansi yatolikwe wase ke naye ke esho ukuthi wanelisekileke yiloko okubhaliwe yiloko okutolikiwe wonke umuntu wasayinda futhi umuntu ngamunye usayinda omunye ekhona.
Daar net bo paragraaf 4 is daar 'n datumstempel en so ook op elke bladsy.
Just above question 4 there is a date stamp and also with regards to each and every page.
Kan u net verduidelik hoekom is dit aangebring?
Can you just indicate as to why it is brought on?
Hierdie datumstempel het ek self persoonlik aangebring by die deurhaal van stukke wat nie van toepassing is nie waar ek geteken het en waar ek geparafeer het sodat dit net 'n aanduiding is van dat dit ek is wat dit gedoen het en die datum is waarop dit gedoen is.
The date stamp was brought on by myself, my lord, where in instances where it was not applicable or the questions were not applicable, I then initialed and then put on the date stamp. Istamp lesike as buzayo ke mtshutshisi mina ke ngasibeka la khona ke imibuzo khona ke eyayingenalutho la kwenza ke mayelana nemibuzo mina ke engangiyibuza ngangibeka istamp bese ke ngifaka ke ama initials.
Dis in die teenwoordigheid van al die partye gedoen.
That was done in the presence of all the parties kwenzeka lokho ke wonke umuntu ekhona.
Yes. En net voor u voortgaan, u het op 'n stadium genoem dat u rekenaar reggestel het toe u met die verrigtinge begin het.
Dis korrek.
You earlier on mentioned that you switched on your laptop just before you started with the proceedings. Yes, that is correct. Ushilo ngaphambilini ukuthi ke use uvula ke i-laptop yakho ngaphambilini kokuthi uqale. Yebo kuyiqiniso.
Was hierdie verrigtinge opgeneem?
With these proceedings recorded.
Dis korrek.
That is correct. Yebo ke ufuna ukwazi ukuthi lokho kwakwenzeka kwa recordwa yini?
Kan u
Yebo
net
kunjalo.
die omstandighede verduidelik?
Can you then explain the circumstances? Ngachaza ke isimo.
En wanneer die opname begin het?
And when the recording started, nokuthi kwaqala nini ke ukwenziwa i-recording?
Hierdie betrokke opname het begin voordat ek begin het met die inskryf van die inligting van hierdie betrokke vorm?
This recording started just before I commenced with the completion of this form. Ukurekhoda lokho ke kwaqala ngaphambilini kokuthi mina ngiqaleke ukuthi ngibhale kuyona iform. Yeah.
Die rede vir die opname is basies dat dit praktyk by my is as ek enige werk verrig in 'n kantoor en nie in die hof waar daar 'n formele opname is of gemaak kan word nie. Dan neem ek die verrigtinge in die kantoor op.
The reason for that, my lord, is that it is just practice to me that when I am doing work in an office environment, unlike in court where there is a recording, then I do my recording, my lord, when I'm doing it in the office. Ukuthi ke mina ke indlela ke ngenza ngayo noma engisebenza ngayo ukuthi uma ngisebenza ke ehhovisi ngenzeke lokho kubizwa ngokuthi ke i-recording ngoba ke uma ngingekho enkantolo ngoba enkantolo ke ikhona i-recording yakhona.
Dis meer 'n persoonlike keuse
It is more a personal choice
en ook vir my eie veiligheid.
and also for my own safety. Into ke mina ke ngayikhethela yona ke nokuvikeleka ke ngakuhlangothi ke lwami.
Was hierdie opname bedoel vir amptelike gebruik doeleindes?
Was this recording meant for official purposes? No. Ingaba lokho ke kwakwenzela noma le recording leyona ke yayenzelwe ukuthi ke izosetshenziswa noma ke official athi cha.
En was die partye ingelig dat dat 'n opname gemaak word van die verrigtinge?
Were the parties informed that they were going to be proceeding, recording of the proceedings?
Nee,
No. Abazange batshelwe ke labo ababekhona ke ukuthi ke lokho okwenziwayo ke ukuthi kuya recordwa.
Ekskuus, ja, u kan voortgaan, u was by paragraaf 4
May proceed, you were in paragraph 4,
op bladsy 3.
page 3.
I informed the deponent that any person who is in custody or has been arrested or any charge has the right to A, be assisted by a legal representative of his choice, B, that if he cannot afford the services of a private legal representative, he has the right to apply to the Legal Aid Board for assistance, and that if he qualifies, the Legal Aid Board will supply an attorney free of charge, and C, that he's entitled to seek legal advice before making any statement to me.
Question 4 ke uthi ngase ngimchazela ke ukuthi nawuphi ke umuntu oboshiweke noma ovalelwe unelungelo ke noma yiliphi ke icala alithwesayo unelungelo lokuthi alekelelwe ummeli okhethwe uyena nokuthi uma kuukuthi ke angeke akwazike ukuthi akhokheleke ummeli oyimele ukuthi ke unelungelo lokuthi ke afakeke isicelo kuyona ilegal aid board ukuthi ke imlekelele nokuthi uma kuukuthi ke utholakala ukuthi ke ukwisimo sokuthi angalekelelwe legal aid noma uyaqualifya ukuthi legal aid board ke izobe isimnikeza ke ummeli simahla ke engeke amkhokhele nokuthi ke unelungelo lokuthi ke aceleke noma izeluleko ke ngezomthetho ngaphambilini kokuthi enze istatement kumina.
His answer is, I understand.
Wasephendula ke ethi ngiyazwisisa.
Do you have a legal representative, or do you wish to apply to a legal aid board for assistance? And if so, do you wish to consult with him before making any statements to me? His answer, Mr. Mjiaku is my attorney.
Mbuzo landelayo ke unayo yini ummeli onayo noma ke ufisa ukuthi wenze isicelo kuyona ilegal aid board ukuthi ke ikulekelele noma ukuthi uma kunjalo ke ufisa ukuthi ukhulumisane noma uconsult naye yini ngaphambilini kokuthi wenze istatement kumina. Impendulo yakhe yathi ke umnumzana uMjiyako noma uMr Mjiyako uyena owummeli wami.
I cautioned the deponent that he is under no obligation whatsoever to make a statement, and that if he chooses to do so, it will be reduced to writing as he speaks and may later be used against him as evidence in court. The deponent is asked if he understands this explanation, and his answer was yes.
Ngase ngimexwayisa ke ukuthi akaphoqelekile nangayiphi indlela ukuthi enze istatement noma uma kuukuthi ke ukhetha ukuthi enze kanjalo ukuthi lokho akushoyo ke kuzobhalwa phansi noma kuzokubhala phansi ke nanjengoba ekhuluma ekungathi kamuva ke kusetshenziswe nanjengobufakazi enkantolo wase ebuzwa ke ukuthi uyakuzwa yini lokho ngichazayo impendulo yakhe yathi yebo.
Question was asked, do you still wish to make a statement notwithstanding the fact that it may be used as evidence against you? His answer is yes.
Umbuzo landelayo ke usafisa yini noma usafuna yini ukuthi ke wenze istatement ke sengishilo ke kuwena ukuthi kungasetshenziswa nanjengobufakazi yasithi impendulo yakhe yebo.
I informed the deponent that he has the right to remain silent and that nobody can force him to make a statement, and that if he chooses to make a statement, nobody can force him to divulge any self-incriminating information. His answer, I understand.
Ngase ngimazisa ke ukuthi unelungelo lokuthula ke angasho lutho nokuthi akekho umuntu ongamphoqa ukuthi enze istatement nokuthi uma kuukuthi ke unquma ke ukuthi asenze istatement akekho umuntu ongamphoqa ukuthi akhulumeke into ezombophezela yena ke noma into ezofaka yena ke kulokho azobe ekusho. Impendulo yakhe yathi ke ngiyezwa.
Do you wish to remain silent or do you wish to continue to make a statement? His answer, I want to continue to make a statement.
Ingabe ufisa ukuthula ungasho lutho noma ufisa noma ufuna ukuqhubeka wenze istatement? Impendulo yakhe ke yathi ngifuna ukuqhubeka ngenze istatement.
Have you used any product that contains alcohol or any drug with a narcotic effect in the last 24 hours? His answer, no.
Ingaba kulamahora awu-24 andlule wayebuzwa ke ngaleso sikhathi ukuthi sikhona yini isidakamizwa sisebenzisile noma ke iproduct enotshwala ke ngaphakathi kulamahora awu-24 andlule. Impendulo yakhe yathi cha.
From the above mentioned questions and answers, it appears to me that the deponent is in his sane and sober senses, and it was required then to indicate whether the deponent appears to be nervous, anxious, relaxed, tearful, jovial, etc., and also whether he has any special request. It was recorded that the deponent was very relaxed, he was calm, he maintained eye contact when questions were asked, first with the interpreter and then with myself. He then made a request as follows: I request a bath to contact my family and have an exchange of clothes and to call my child.
Lana ke kule mibuzo ke lena ke endlulile kanye futhi nazo ke impendulo ke kuyabukeka ke kumina ke ukuthi lona ke ngihlezi naye noma engikhulumisana naye ke usemqondweni ngokuphelele kwase kuchazwa ke lana ukuthi chaza ke noma ke indlela ke abukeka ngayo ubukela ethukile yini noma nervous ubukeka relaxed epholile yini noma ubukeka enenyembezi ubukeka eneme noma ke ethokozile noma futhi sikhona ke isicelo anaso lana ke ngase kubhala ke ukuthi ke hayi cha ke lo muntu lona ke akatatazeli urelaxed ukham kanye futhi ke uyabhekana ke akusukuthi umuntu obalekisa ke noma ugijimisa ke amehlo wenza lento abayibiza ngesilungu ukuthi ke i-eye contact uma kuukuthi ke imibuzo noma ephendula imibuzo okokuqala uma ekhulumisana naye utolika, okwesibili uma ekhuluma nami. Isicelo ke awasenza ngicela ukuthi ngigeze ukuthi ke ngixhumane nomndeni wami nokuthi futhi ngishintshe ke impahla noma ngiboleze engiyigqokile nokuthi ke ngishayele ucingo ingane yami.
I now asked the deponent to tell me in his own words how he came to be brought to my office to make this statement.
Ngase ke okulandelayo ngimbuza ke ukuthi angitshele ukuthi kwenzeka kanjani ngokusho kwakhe ukuthi kwenzeka kanjani ukuthi alethwe ehhovisi lami azokwenza sona istatement lesi.
My Lord, also as far as this paragraph is concerned, certain portions have been redacted. From the lees tot waar die sin eindig met die woord death, dan die volgende twee sinne oor te slaan en te begin met die sin wat begin, I was arrested on the 16th.
Okay, sorry. Can I just request you to read up until where it ends with a death, and then skip the next two sentences and start where it says, I was arrested on the 16th.
His answer to the question, the police called me and asked me if I know of Senzo Meyiwa's death.
Lana ke impendulo yakhe ke ifundeka ngalendlela. Amaphoyisa aqhumana ke nama noma ke angishayela ke ucingo angibuza ke ukuthi ngiyazi yini mayela nokushona. Okay. Yana bhale Senzo Maye nokushona ke kwakhe uSenzo Maye.
Yeah, just spell that name as it appears there.
Meyiwas.
Oh, it's the same word. Okay. Lana ke kubhale okay. Well, amaphoyisa angishayela ucingo angibuza ukuthi ngiyazi yini mayela nokushona kwakhe ke uSenzo Meyiwa. Yeah, Senzo Meyiwa.
How would you pronounce it? Who shall it say?
I heard it as Senzo Meyiwa, and I wrote it as I heard it.
Engayizwa ke mina ngendlela engayizwa ngayo ngenza njengo Senzo Meyiwa ngase ngibhala ngaleyo ndlela engayizwa ngayo.
Goed, you can voortgaan. I was arrested.
I was arrested on the 16th. I saw no progress.
Sorry, you can proceed.
I didn't see or understand what was going on. I didn't understand when I was supposed to appear in court. I knew I was arrested. If one is arrested, they have to appear in court. I decided to come to court. I called my attorney and told him I wanted to come to court.
Lana ke ngaboshwa noma elandelayo ke ngaboshwa ziwu16 ngase ngibona ke kungenanqubekela phambili ngangasazi ke noma ke nginga-understand ukuthi ke kwenzekani ukuthi kwangani ke ukuthi ngingaveli ke enkantolo ngangazi ke ukuthi noma kuyinto engiyaziyo ukuthi uma kuwukuthi umuntu uboshiwe lo muntu lo kufanele ke ukuthi ayovela ke phambi kwemantshi noma kavele ke enkantolo ngase ngithatha isinqumo ke sokuthi ngize enkantolo ngashayela ke ummeli wami ngamtshela ukuthi ngifuna ukuza enkantolo.
The following questions are now put to the department. Do you have any injuries or bruises of any kind? If so, please show them to me if it is possible for you to do so.
Yile mibuzo elandelayo ke ase eyibuzwa ke ukuthi unayo yini imihuzuko onayo noma ke ukulimala noma ke kwayiphi ke indlela uma ke kunjalo ngicela ke ungitshengise noma ungikhombise ke uma kukwazi ke ukuthi kwenzeke lokho.
Answer: no, except old injuries sustained while I worked underground, the one I got when I was very young, and the one I got when I was very young.
Wase ephendula ke ethi cha ngaphandle nje kokuthi ke ngalimala ke noma ke amanxeba ke amadala engawathola ke nkathi ke ngangisebenza ke ngaphansi ke egodini elinye futhi ke ngalithola ke ngisemncane.
Who inflicted these injuries on you, and how were it, and where did it happen? It was repeated, and I then referred to paragraph A.
Ukuthi ubani ke owakulimaza nokuthi ke kwenzeka kanjani noma kwenzeka kuphi ke wase ephinda ke lempendulo ke ebesenikeziwe ngapha ingakho ke lana ngishilo ke ukuthi ke ebheka ke ku paragraph A.
I reported and recorded my observation, and it was recorded in brackets: no noticeable recent injuries, a scar healed on the right side forehead, allegedly sustained when he was very young.
Ngase ngibhala phansi ke lokho engikubonayo ke noma ke uma ngimbuka ke ukuthi ke awekho ke amanxeba ke abonakalayo ke noma ke kunescar esikhona ke kuhlangothi langaku right ke ekhanda futhi ke kubonakala ukuthi ke sesipholile ke nokuthi nokusho ukuthi ngathola ke ngisemncane noma ke lokho kulimala ngakuthola ngisemncane.
It was then instructed as per this former to note the particulars of any visible injuries and to ask the department if it agrees with what has been recorded. The court, myself, recorded 2 scars, injuries on the right side of the forehead and a small scar above the left brow, both already healed. The second scar was pointed out by him during this process.
Lana ke ile form ke iyachazela ke ukuthi uma ke kuloko kubonayo ke uma kukhona ukulimala okubonakalayo okubonayo ke wena ke nokuthi ke umbuzeke ukuthi uyavumelana yini nalokho okubhaliwe. Ngibhale lana ke ika ezimbili esoqala ke kuhlangothi langaku right ke la esiphongweni kanye futhi ke neska esincane nje ngaphezulu lana ke kwehlo noma ke kweshiya ke lona ke leso isikhathi sona sakhonjwa uyena ke kuyena ke le process uyena wangikhombisa sona.
The department's comments, yes, both sustained as a small child when my grandmother tried to hit a chicken and the blow landed on my forehead.
Lana ke inqa ukuchaza kwakhe ke noma ke uma yena ke sengichazela ukuthi yebo ke zoyimbili ke ngalimala ke ngisemncane ila khona ke ugogo wami ke wayezama ke ukuthi ashaye inkukhu kodwa ngeshwa ke wase eshaya mina.
He was asked, did the police or any other person assault or threaten you to make the statement? Answer, no, not at all.
Umbuzo landelayo ke ngamaphoyisa noma nje noma uyimuphi umuntu ke owakushaya noma owakusabisa ke ukuthi wenze le statement cha naka lutho nje.
Did anyone influence you to make the statement? Answer, no, I decided on my own.
Ingabe ukhona yini umuntu owaba nomthelela ukuthi wena uzokwenza lesi statement lesi cha isinqumo engayithathela mina.
Did anyone encourage you to make the statement? Answer, no.
Khona yini owagqugquzela ukuthi wenze le statement cha.
Were any promises made to you to persuade you to make the statement? Answer, no.
Ngaba ikhona yini izithembiso ezenziwa kuwena ukuthi ke noma ke ukugqugquzela ukuthi ke wenze statement lesi impendulo yathi cha.
Do you expect to derive any benefits from making the statement? Answer, no, not at all.
Ngaba kukhona yini ofisa ukuthi ukuzuze noma ukuthole ngokwenza lesi statement impendulo yathi cha.
The department is now informed that he cannot expect any benefits whatsoever from making the statement. The importance of this aspect is now stressed to him and he's asked whether he understands this. His answer, yes, I understand, and I was never promised anything.
Lana ke useyachazelwa ke manje ukuthi ke ungalindeli lutho ke noma ungalindeli ke ukuzuza noma ukuthola noma yini ke ngokwenza sona ke lesi statement futhi ke nokubaluleka ke kwalokhu kuyagcizelelwa ke manje ukuthi ke akuzwe noma ke ukuthi uyabuza ukuthi uyakuzwisisa yini lokho. Yebo ngiyakuzwa futhi ke angikaze ngithenjiswe lutho.
Seeing that you can't expect any benefits from making the statement, do you still wish to continue to make the statement? Answer, yes.
Nanjengoba ke manje ke swazike noma ke ukuthi ke akukho nje inzuzo noma ke ongayilindela ke ukuthi ukukhona ongakuthola usafisa yini ukuthi uqhubeke wenze le statement impendulo yathi yebo.
Have you made a similar statement previously? And if so, when and to who? Answer, no.
Ingabe sikhona yini istatement salolu hlobo noma esikanjena ke osenzileke ngaphambilini uma kuukuthi kunjalo kubani wase ethi ke cha asikho.
You have now told me that you were not influenced, encouraged, assaulted or threatened to make the statement, and that no promises were made to you in order to persuade you to do so. I wish to once again ask you to take me into your confidence, and tell me if, in your opinion, anything irregular has been said or done to influence you to make a statement. I undertake to ensure that your allegations are immediately and properly followed up and attended to. Answer: no, nothing of that sort.
Manje usungitshelile-ke ukuthi-ke akaze kube nomuntu onomthelela, awukazi ugqugquzelwe, ushaywe noma usatshiswe ukuthi wenze le statement lesi, nokuthi-ke azikho iy'thembiso ezenziwe kuwena ukuthi-ke wenze noma-ke ukushintsha-ke umqondo ukuthi wenze kanjalo. Ngifisa-ke manje-ke futhi-ke ukuthi ngikubuze noma ngikutshele-ke ukuthi ngicela ungethembeke noma ungitshele ukuthi ngovo lwakho kukhona yini into engahambanga ngendlela noma engenziwanga ngendlela noma-ke eshiwo kuwena ekwenzile ukuthi-ke kube nomthelela ukuthi uzokwenza le statement lesi. Ngiyakuthembisa-ke ukuthi iy'nsolo zakho zothi zilandelweke futhi-ke zinakwe. Cha, akukho nje ayikho nje into ekanjalo.
Do you understand everything that I have explained to you, or is there anything that I need to explain again? Answer: I understood very well.
Ingabe uyakuzwisisa, uyakuzwa konke engikuchazele kodwa noma kukhona ofisa ukuthi ngikuchaze futhi? Impendulo yathi-ke ngikuzwe kahle.
The deponent then made a statement.
Wase-ke manje enza-ke istatement sakhe.
Yes, you can proceed. Read the rest of the.
The deponent made his statement, which was attached hereto as Annexure A. The statement is reduced to writing as he speaks and is written down in the deponent's own words. The statement consists of 6 pages marked 1 to 6. Each of these pages must also be signed by the magistrate, deponent, and interpreter, which was done in each other's presence.
Manje-ke useyasenza-ke istatement sakhe sikhona-ke esihlanganisiwe-ke lana esiwu-Annexure A. Istatement leso-ke senziwa-ke ku-page entsha, futhi-ke sibhalwa phansi-ke nanjengoba ekhuluma, futhi-ke kubhalwa amazwi akhe-ke lawo awashoyo. Le statement lesi-ke sinama-page awu-6 aphawuleke ku-page 1 kuyofika-ke ku-6, ukuthi i-page ngayodwa-ke kufanele isayindwe-ke umagistrate loyo-ke owenza istatement kanye notolika.
Now questions are asked, except such questions as are necessary to clarify aspects of the statement which are unclear. Such questions, if any, and the answers thereto are clearly indicated as such. The statement is made in Zulu language and interpreted into English by the interpreter.
Ayikho-ke imibuzo ebuzwayo-ke ngaphandle nje kwemibuzo la ekungacacile khona-ke ecalwa-ke ukuthi-ke achazwe noma acaciseke uma kukhona nje okungazwisiki kahle. Imibuzo enjalo-ke uma ngabe ikhona-ke kanye ney'mpendulo zakhona-ke zibhalwa-ke ngaleyo ndlela-ke istatement senziwe ngesiZulu sabe sesiyahunyushwa-ke hunyushwa ngeSingisi noma-ke nge-English uyena utolika.
The statement is read back to the deponent and translated by the interpreter.
Istatement-ke uyasifundelwa-ke manje futhi-ke sibe sesihunyushwa-ke uyena utolika.
The deponent is asked whether he confirms the content of the statement as correct, and he answered yes.
Useyabuzwa-ke ukuthi manje-ke lokhu okubhaliwe-ke kanjalo-ke noma ku-right yini, waphendula wathi yebo.
Statement is signed by the deponent by means of his signature.
Wase uyasayinda-ke ngokuthi-ke abeke i-signature yakhe.
Statement is also signed by the interpreter and by myself.
Sisayindwa na uyena-ke utolika kanye futhi nami-ke.
The date stamp was put and the time of completion indicated as 20 minutes past 5 the afternoon.
Istempu-ke laphaya-ke sesichaza i-date-ke sibekiwe nesikhathi-ke ekwaqedwa ngaso ekwaku-20 past 5 emini.
Certificate by the interpreter was also completed and attached. and signed by all present,
kusikhona
with reference to the interpreter, the deponent, and the magistrate.
sikhona-ke ne-certificate lapha-ke ekuyi-certificate sakhe-ke uTolika sisayindwe uyena-ke umuntu umagistrate laphayana ezansi yena-ke lo wenza istatimende ubekela ama-initials wakhe kanye naye uTolika.
Yes, we've already referred to the copies of the three police officers.
It was also attached and initialed by the interpreter and the deponent.
Kanye nalamakhophi-ke amathathu awo amaphoyisa nawo-ke abekiwe-ke nama athachiwe-ke afakiwe lana ase futhi initial uyena uTolika kanye naye-ke lo wayenza
And
istatement.
I stamped these documents.
Mina-ke ngase ngibeka nje istamp kulama document.
The stamp used is a stamp that was allocated to me in person and signed out to me as magistrate.
Istamp lesi-ke istamp-ke engasinikwa-ke futhi-ke esasayindwa-ke sayindelwa kumina-ke nanjengomantshi.
Do you confirm the correctness of this document?
Correct?
Exhibit JJ.
Le document-ke ngivumelana ukuthi-ke iyiqiniso noma kuyiqiniso-ke lokhu okula.
What did you do with the document, Exhibit JJ, after the proceedings?
After the parties left the office, that includes the interpreter, the deponent, his attorney, I then handed the document to Mrs. Du Plessis.
Emuva kokuthi bese behambe bonke-ke ummeli lona-ke wenza istatimende uTolika ngase ngithatha-ke mina idocument lena-ke le ebengibhala kuyona-ke ngayindlulisela ku-Mrs. Du Plessis.
She then made copies for the files and handed me a copy later that week.
Wasenza-ke amakhophi-ke ayezoya-ke kwi-file wanginikeza nami-ke ikhophi kamuva-ke kulelo viki lelo.
Nou, na afloop van die verrigting, van die afneem van die verklaring, wat het toe daarna gebeur?
Now, after the proceedings, now after taking down the confession, what then happened?
Dis nou met betrekking tot die partye wat in die kantoor was.
With regards to the parties that were present in the office.
Die party het my kantoor verlaat en nadat ek alles opgepak het en ek die kantoor verlaat het, was hulle nie meer in sig in die gang gewees nie en het ek hulle nie gesien nie.
After the parties then left, and after I had packed everything, and I also left the office, they were not in sight anymore, and I also didn't see them in the passage. Angibabonanga-ke emuva kokuthi sengiqoqe konke ngase ngiphuma-ke kulelo hhovisi lelo babe bengekho-ke nalapho kuleyo passage leyo babengekho ngaphambilini ushilo-ke futhi nokuthi-ke wase ethatha-ke le document lena wayonikeza ngayo ku-Mrs. Du Plessis owenza-ke amakhophi amanye wafaka-ke ku-file kamuva-ke kulelo viki wamnikeza nayo.
En meneer Mjiako, die prokureur wat die deposant bygestaan het hy in die kantoor gebly vir die duur van die afneem van die verklaring.
Dis korrek.
Mr. Mjiako, who represented the deponent or assisted the deponent, was he in the office for the duration of the taking of the confession? That is correct. Yebo, Mr. Mjiako wayekhona ngaso sonke leso sikhathi leso i-confession lena-ke ibhalwa-ke noma ithathwa.
As ek kan vra om te gaan na paragraaf 9 op bladsy 4.
If I can ask you to go to paragraph 9 of page 4.
Veral die laaste gedeelte van daardie paragraaf.
The last part of that paragraph.
I decided I want to come to court. I called my attorney and told him I want to come to court. Hoe was u gekleed op die betrokke dag?
Ek self.
Ja, was u in hofklere gekleed of in privaat klere?
How were you clad on that day? Were you in your court regalia or were you in your private clothes?
Ek het nie my toga aangehad nie. Ek was in gewone siviele drag geklee gewees.
I didn't have my robe on. I was in my normal civilian clothing. Ngangayifakileke igown noma irobe yami ke yoba umantshi ngangigqoke nje impahla zami.
The court, please, my lord, those are the aspects that we wanted to take up with the witness in light of the discussion earlier on. May the cross-examination then stand down until tomorrow.
Of the recalling of whatever.
Court pleases, my lord.
Yes, sir.
My lord, I have an instruction to bring an application for the recalling of Colonel Mboto, who has finalized his testimony and he was cross-examined in terms of Section 167 of Act 51 of 1977.
Is it not Act, is it not Section 166, subsection 3?
167, the recalling of
Is
the...
it 167?
That's correct, my lord.
Okay. Hello? I see.
Just confirm.
This is the court, madam.
No, just check. Is section what?
It's in terms of section 167.
Oh, sir, yeah.
Run together with 186, my lord. The one, as I said before, is the court Meromoti calling the witness. The other is the defense making an application to recall the witness, but they are read together, my lord. As the court says.
Yeah, so it's 167, Mr. Mugumizulu.
That's correct, madam.
Subsection 3.
Subsection 3.
We are quoting only that. or-
Only that aspect
We are
only.
reading it together with 186,
That's correct, my lord.
right? And also what?
That is all. That will be in relation to the cross-examination of the witness on certain aspects.
Yeah, you are aware of the provisions of the law. I mean, you're a senior counsel, are you not?
I'm aware, my lord.
Right. Just to recap, Colonel Mboto has already testified. Is that not so?
That's correct, my lord.
And he has already been cross-examined. Right?
That's correct, my lord.
The law stipulates, I'm saying they must bring the decisions. It is tried that once a witness has been cross-examined, it's possible for you to make an application and forward or present cogent, plausible reasons why the witness should be recalled. In this case, Mboto has completed his evidence, in other words. The only aspect which I think you are making an application for is that he must be recalled. But you recall that he was cross-examined by an officer of this court, Attorney
Mr. Ramsey.
Ramusipidi.
Correct.
And the law says no two legal representatives can cross-examine a single witness. Is that correct, sir?
That's correct.
That's the law. But this court, in fairness to you, I'll quote you the decisions. The State versus Basson, State versus Yanti, where the principle is reiterated that legal representatives who represent a single witness are not, without leave of the court, permitted to cross-examine jointly that witness. If one legal representative like you are seated here, Mr. Ramusipidi is cross-examined, that is the end of the matter, unless there are extraordinary and compelling circumstances which impel you to recall this witness. And as I understand you, it is, you want this witness to be recalled for further evidence, for further cross-examination. The way I understand the law, whatever he has testified to and whatever he was cross-examined on cannot be, as a matter of course, be repeated. Is that not so, sir?
That's so. That is correct, ma'am.
All right,
That
let's
is-
quote the authorities, because people will say, hey, you Judge Lily, hey. Yeah. Let's just first read, you can do it, that, Mr. Ngumuzulu. Let's just first read section 167, subsection 3. Maybe start with the whole section so that for the uninitiated it flows logically.
My Lord,
No, I know you know the law, but just read it. So
may I
that this
request, may I request my colleague
Oh,
to
yeah,
read
to read it. Yeah, fine.
for eyesight
Oh,
problem?
that's so.
Yes.
Mr. Ramasipedi. What is it?
My Lord, if I may read, Section 167 in particular
Yeah.
refers to, and I quote, 167, the court may examine a witness or a person in attendance. That deals with when the person is recalled by a court. Should I read that, my Lord?
Yeah, read it.
Okay. The court may, at any stage of criminal proceedings, examine any person other than an accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and may recall and re-examine any person, including an accused already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if the evidence appears to the court essential to the just decision of the case. And then let's go to section 186. It says, the court may subpoena a witness. The court may, at any stage of criminal proceedings, subpoena or cause to be subpoenaed any person as a witness at such proceedings, and the court shall so subpoena a witness or so cause a witness to be subpoenaed if the evidence of such a witness appears to the court essential to the just decision of the case.
Yeah, fine.
Is that correct?
Yeah, so if we're at idem with the law, let's just adumbrate the principle, just in case this case goes any other place. This is the case of the state versus Yanta. The citation is 2001 in brackets SACR 287. It's a judgment by Van Zyl, as he was when he was in the High Court of the Transkei. I'll just read the last sentence, paragraph, which is important in my view. Finally, a matter that requires mention relates to the procedure adopted by the magistrate at the hearing of the application for bail. The appellant was represented by two attorneys who were permitted by the magistrate to take part in the conduct of the case to the extent that they were both allowed to cross-examine each witness. Mr. Carpenter, who appeared on behalf of the state, submitted that the procedure was irregular, as I do. I agree with the submission. When an accused person has more than one legal representative, only one may then cross-examine a particular witness. C. Ferreira, Strafproces en die Leierhoeve, second edition at page 387, and see also Pretoria's cross-examination in South Africa and South African law at page 132, and see also Wigmore on evidence, volume 3, paragraph 783. The ratio against such a practice is to protect a witness from being exposed to protracted cross-examination and not to unnecessarily prolong the proceedings. Wigmore, cited at paragraph 783, explains it as follows. This tradition rests on the wise policy of protecting the witness from undue and confusing interrogation, as well as securing a system and brevity by giving the control of the interrogation to a single hand. Although the procedure adopted by the magistrate in the present case or the present matter was irregular, it did not in any way prejudice the appellant and does not affect the validity of the proceedings. Right? Hatzenbeck also, in the case of the State versus Basson, who was popularly known as Dr. Death, had this to say. He says it's in Afrikaans, ek sal dit moet lees. On page 533, that citation is State versus Basson, 2001, 2 SACR 537. Ratzenbeck, as he was in this division, had this to say. Dit word aanvaar deur die stad dat daar 'n praktykreël van Tuka se daai bestaan wat kruisverhoor van een getuie deur meer as een regsverteenwoordiger van 'n besondere litigant verbied is. It's not allowed. Die argument is egter dat 'n buitengewone omstandighede die hof 'n diskresie het om af te wyk van die reël en dat hierdie sake omstandighede is. Ek moet aantoon dat die verdediging wat die aansoek teenstaan toegee dat die hof en so 'n diskresie het maar aangevoer dat in hierdie geval die hof nie behoort af te wyk van die reël nie. Volgens Wigmo en Evidence, derde volume, bladsy 783 en die bogemelde reël gebaseer op 'n wyse beleid om getuies te beskerm van onnodige en verwarrende tuisondervraging en om 'n kort en kragtens stelsel te versigtig en verstig. Die reël is 'n onontwowige gevolg. Nie een van die advokate kon 'n geval uitwees waar onder normale omstandighede daardie reël afgewyk is nie. Ja, he says, not in South Africa. Once a witness has been cross-examined by one of the attorneys or advocates representing an accused person. Once that cross-examination has been done by, for instance, Mr. Mgomezulu, Mr. Ramusipidi, he is not entitled as of right to do that because, as they say, cross-examination, although it is a right encapsulated in section 35.3 of the Constitution, it is not an absolute right. But me, being fair, I'm going to do like Basson in this case, where he allowed two sets of advocates to cross-examine because the charges were voluminous. And so he was justifiably entitled to use his discretion to advance the completion of the case like I'm doing. I'm going to relax that rule and with the proviso that what has been discussed and cross-examined by your colleague, Ramusipidi, is not to be done. Actually, I was intending that the record of the proceedings between Colonel Mboto, the cross-examination, the examination and the cross-examination by Mr. Musipidi must be at hand so that if you wander away from that evidence and cross-examination, I must be able to tell you that. But I take it as an officer of this court, you have heard me. So the cross-examination is allowed on condition that it goes from what was cross-examined here to aspects which you believe, after your consultation with your clients, those aspects were not covered by Mr. Ramosipidi. Okay.
Court, please, my lord. My lord, may I be...
Let's hear your learned brother. Maybe any comment, Munir?
As a court, please, my lord. Well, firstly, the sections quoted by my learned friend, I don't think they're applicable.
It's not 167, it's 166. Is that not
Yes.
so? Just read 166.
166, my lord, states...
That's what gives you the rights in terms of our constitution,
Yes.
our Criminal Procedure Act to cross-examine. 167 deals with where you want to recall a witness, etc., etc.
Yes, but 166 deals generally with the
That's it.
cross-examination of
Yes, just read that.
subsection 1 of section 166. The heading is cross-examination and re-examination of
That's it.
witnesses. An accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings, or any co-accused who testifies at criminal proceedings, or any witness called on behalf of such co-accused at criminal proceedings. And the prosecutor may cross-examine any witness, including an accused, called on behalf of the defense at criminal proceedings, and a witness called at such proceedings on behalf of the prosecution may be re-examined by the prosecutor on any matter raised during cross-examination of that witness, and a witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. Subsection 2, the prosecutor and the accused may, with leave of the court, examine or cross-examine any witness called by the court at criminal proceedings. And then subsection 3A, if it appears to a court that any cross-examination contemplated in this section is being protracted unreasonably and thereby causing the proceedings to be delayed unreasonably, the court may request the cross-examiner to disclose the relevancy of any particular line of examination and impose reasonable limits on the examination regarding the length thereof or regarding any particular line of examination. And subparagraph B, the court may order that any submission regarding the relevancy of the cross-examination be heard in the absence of the witness. My lord, the court has outlined what the legal position is, and it's clear that from the authorities quoted by the court that cross-examination by more than one counsel should not be allowed unless the defense demonstrate exceptional circumstances. And in this instance, my lord, we haven't heard what those exceptional circumstances are. So we submit, my lord, that as it was mentioned in the Basson's case, that this rule can only be relaxed if exceptional circumstances are demonstrated. We would request that the defense should, the court has already made a ruling, but our view is that the defense must demonstrate those exceptional circumstances.
Yes, Mr. Ngomezulu.
My lord, just received instructions from Mr. Ramosipidi. The court has already made a decision or in order in relation to the application.
Yes, I have.
But what has come to my attention at the moment, especially on the submission that the state has made regarding the exceptional circumstances, it would be a futile exercise to re-cross-examine the witness if such exceptional circumstances could not be established at the moment, despite the fact that the court has already made a ruling. Furthermore, Your Lordship, is that it will be a difficult practical exercise without the transcripts of the examination in chief and the cross-examination to pinpoint the questions that are relevant in order to establish what could be exceptional circumstances that may warrant the witness to be re-examined, to be cross-examined again by another counsel. In the circumstances, as I've indicated, my instruction is to abandon the application despite the order of the court.
Okay.
Court, please.
No, thanks.
Ukuthi bekunesicelo sokuthi uKenneth Mboto aphinde abizwe futhi senziwe leso sicelo uyena-ke u-advocate uMngomezulu noma-ke ebesebuziwe-ke imibuzo uyena-ke uMr. Ramusipile. Inkantolo ibisifunda-ke amacala athile-ke ayisibonelo noma-ke asetshenziswayo-ke nanjengomzekelo achazayo-ke ukuthi akuvumelekile-ke ngokomthetho ukuthi la khona-ke umsola noma-ke abasola benommeli asithi mhlawumbe ababili-ke noma abathathu ukuthi uma omunye ummeli esebuzile nowesibili futhi ommele kwaleyo msola oyedwa nayo-ke aphinde abuze imibuzo ufakazi besebuziwe, kodwa-ke yanquma inkantolo ukuthi cha noma kukanjalo kodwa izobanikeza-ke ithuba lokuthi cha uKenneth Mboto nekholisakhe ukuthi akaphinde abizwe, kodwa-ke manje uma sebephinde bakhulumisana-ke abameli bona-ke bobabili bathi cha-ke uma kuzodingeka-ke ukuthi akuphinde futhi kuyolalelwa irekhodi ukuthi-ke umshushisi ekhulumisana ngani kanye noKenneth Mboto uMr. Ramusipile yini ambuze yona, babona-ke ukuthi cha angeke-ke ukuthi manje-ke abasaqhubekeki naleso sicelo leso noma inkantolo-ke ibisibavumele ukuthi cha basengambiza-ke uKenneth Mboto, kusho ukuthi-ke ummeli ka-accused number 1 and number 2 abasaqhubekeki ngalesi sicelo sokuthi uKenneth Mboto aphinde abizwe.
Okay, where's Kenneth Mboto? He still has to come anyway, depending, of course, on the exigency whether. Yeah,
Yes.
he still has to come.
The ruling that
Yeah,
is
of
going to be
course.
made at the end, yes.
Yeah. Hello. Oh, Mr. Ramsey, I thought you were saying something. Okay, so we adjourn until tomorrow. And then for this evening, councils, all of councils were involved. Then they must listen to the tape, the recording, so that when we come tomorrow with the cross-examination, the cross-examination must
The court, please, my lord. The state calls the next witness. It's Mrs. Vivian Cronier. My lord, while she's still on the way, we have further redacted the pro forma which she'll be using. My colleagues have made an input in that exercise. It's been handed up as Exhibit JJ, if I'm not mistaken. Is witness number 91 on the list? And in light thereof, my lord, will then request that the previous exhibit JJ be retrieved so that we can hand up this one that has been redacted.
Just before we start, Madam, can you just double check the spaces that have been blocked containing the incriminating evidence?
We will provide a copy to my colleagues.
I don't have to see that document.
Thank you, my lord.
My lord, this is the redacted copy.
Yeah, I'm saying in terms of the law, I don't have to see that document until.
Yeah, but this is just a pro forma. This is just a pro forma, not a statement, my lord.
I'm aware of that. Because when Colonel Mboto was testifying, you never handed up. Remember?
We did hand up the pro forma.
No, we never.
We handed up exhibits that the state was going to use in the, I think it was exhibit GG.
Yeah, fine. If you have a copy, fine. You hand it up when the time comes.
Yes, it was exhibit GG, and the photos, we handed up the photos that we are going to use as exhibit GG1.
The photos.
Yes.
Exhibit GG1.
Sorry, my lord, the magistrate is on her way.
Yeah, fine.
May I also approach my learned colleague to refer also to a passage that the defense believes it should be also redacted at this stage?
I thought you did that before I came to court.
We were just beginning the process, my lord, waiting for the court before I do so.
Just for my understanding, is that a statutory form?
Yes, my lord, it's a pro forma.
Is it a statutory form?
Well, I don't think there's any prescribed format, my lord.
Is that a statutory form?
No, it's not, my lord. It's just a rule of practice that the presiding officers and justice of the peace use, my lord. So it's just a guide, a rule of practice, my lord.
Okay. And who compiles that rule of practice?
Well, like in this instance, my lord, the senior magistrate for a particular office would keep the pro forma, and when the need arises, the magistrate will then go to that senior magistrate and request a copy. So it's a practice that has developed throughout the years, my lord, just to make it easier for the process to be finalized, my lord.
And in the compilation of that rule of practice, as you say, it complies with Section 35 of the Constitution.
Yes, indeed, my lord.
Now, what are you reducting?
Well, during the process, my lord, of asking those introductory questions, certain things will be said by the deponent that are separate from the statement itself that should not, at this stage, my lord, be contained in the pro forma. Now, we're removing those portions until the prerequisites, my lord, have been determined. So in other words, those are the portions that were said by the deponent that actually belong to the statement itself. So we're removing them at this stage already, my lord, until the admissibility has been determined.
Okay. In Afrikaans? No, no problem.
The volle naam,
Swear the witness in.
die volle naam van asseblief.
Vivian Cronje.
Okay, die enige beswaar om u eet te neem.
Nee.
Zweer u dat die getuienis wat u zal afleveren de waarheid zal wees, die volle waarheid en niks anders als de waarheid nie. Steek je rechterhand op en sê so help my God.
So help my God.
The witness is sworn in, the full names are Vivian Cronje.
Yeah.
Soos jy opberg, die proforma's in Engels en die getuig in Afrikaans. So ons sal moet op 'n stadium besluit oor die taalkwessie.
Nee, die getuie verkies om te getuig in Afrikaans. En Afrikaans in termen van onze constitutie is een taal wat bekrachtigd is. So if he prefers to testify in Afrikaans, you must proceed in Afrikaans. It means you must translate those pro forma forms as they are worded, unless you have an Afrikaans version.
As a good please, my lord, we only have the English version, but we will proceed in Afrikaans.
This indicates, my lord, the question can be in English, you just respond in Afrikaans.
Oh, I see. Okay.
Ik wil verder onder die op zijn aandacht brengen dat er een audio-opname van die onderhoud wat mevrouw Cronje met die deposant gehad het. Die audio-opname is beschikbaar. Ik heb voor mijn collega's meegedeeld dat daar die opname is beschikbaar. Ons gaan echter niet die audio-opname gebruiken, nie, maar dit is tot die beschikking van ons collega's.
There's also an audio recording that Mrs. Cronje did with the deponent. Indicated to my colleagues that that audio recording is available. We are not going to make use of it, but I placed it, made it available to my colleagues.
Okay.
En verder, jullie is ons aangeduid dat is een proforma. Al die gevraagde gedeeltes is uitgewis en ons gaan op hierdie stadium verlof vra om die verlofvorm in te handig. Dis eintlik reeds ingehandig as bewijsstuk JJ. Ja, JJ. My collega's het insit gehad aan al die gevraagde gedeeltes wat uitgewis moet word.
We've already made mention, my lord, that there is a proforma and there's also some parts that have been spelled out, and those were also indicated, or my colleagues know about that, and the form has already been handed in as Exhibit JJ.
Okay. Ja. Waar die afschrift?
Ons aandag die geredakteerde weergawe op. Ons sal dan vra dat die vorige afskrif wat ingehandig is aan ons terugbesorg word.
Ek is nie bewus van 'n afskrif wat ingehandig het in hierdie hof nie.
Okay.
Daar is nie so 'n afskrif aan my.
Soos jou dag, dan vra ons verlof om dan die geredakteerde afskrif as bewystuk JJ in te dien.
Okay.
Requesting to hand up this version as Exhibit JJ.
And the one of Colonel Mboto will be exhibit, as you said.
It's GG.
Of Mboto is exhibit GG, okay? You'll have to hand that one.
Sorry,
also
Mboto is
up.
FF, I'm sorry, my lord.
See.
Exhibit.
So it's FF.
Yes,
on Mboto.
FF.
Okay.
So far, the following exhibits have been handed up in a trial within a trial. Is Exhibit EE, the charge sheet of proceedings in the lower court in this matter.
And that was also, you have attached it to my
Yes,
bundle.
indeed.
Exhibit EE.
Yes,
Right, charge sheet in the lower court.
yes.
Right.
Exhibit FF is the pro forma, confession pro forma for accused number 1 to Lieutenant Colonel Mboto on 30 May 2020.
Yeah.
Then there's Exhibit GG. It's a pro forma of pointing out by accused number 1 to Lieutenant Colonel Khadebe on 5 June 2020. And attached to that are photos that have been handed up as annexure GG1.
GG7.
No, GG1. Photos 1 up to 7.
Yes.
Yes.
So it's GG1, GG2, 3, 4, 5, 6, and 7.
Yes, as the court pleases. Then Exhibit HH was a pro forma for a confession made by accused number 2 to Lieutenant Colonel Rapadu on the 19th of June 2020. Then there's this exhibit that we've just handed up, the pro forma confession by accused number 2 to Magistrate Grenier.
All right.
Now, my lord, at this stage, the state is going to lead evidence of a statement made by a person. The name of that person corresponds with the name of the accused. In terms of Section 217 of Act 51 of 1977, to a magistrate.
Right.
There was a catch-all explanation given at the beginning that all these statements are going to be disputed on the basis that they were not freely and voluntarily made.
Right, so.
Subject to confirmation by my learned friend, I suppose that is also applicable to the current statement.
Which Mrs. Kronje is going to testify of?
Yes, indeed, my lord.
Is it a statement or a confession?
Is it a statement in terms of 217?
Okay, 217, it's a confession then.
Yes, it is a confession.
Right. Is it being disputed, the admissibility thereof? Mr. Mlowizo? Is it being disputed?
It is being disputed.
On what basis?
On the basis of that it has been obtained under duress.
Obtained under duress.
Correct. That the deponent did not sign the statement.
The deponent did not sign the statement before Mrs. Grenier.
Correct.
The deponent did not sign the statement before Mrs. Grenier. Right?
And lastly, my lord, the statement
was not made as alleged freely and voluntarily by the deponent.
So the statement was not made freely and voluntarily.
That's correct, my lord. Court, please.
Izathu-ke ayinikezayo ummeli athi-ke imbangela yokuthi kufaneke nale statement ufakazi azofakaza ngaso ukuthi-ke okokuqala le statement lesi-ke akazange noma-ke waphoqwa-ke owayinikeza ngaso waphoqwa ukuthi-ke anikeze ngaso akazange futhi asayinde phambi kwakhe-ke umagistrate lona ukhona lana ozoba ufakazi nokuthi futhi-ke akazange akusho noma-ke lokho okulapho okubhaliwe lapho kwangaphumi kuyena-ke ngokuyithandela.
Just one aspect, Mr. Jonas, I know you for years. You are competent to interpret from Afrikaans into English, English into Zulu, Afrikaans into Zulu, and vice versa.
Correct, sir.
Yeah, let's put it on record. Because we have to interpret in English for, I don't know, for some of our colleagues who don't understand Afrikaans. Are there people, colleagues here, who don't understand Afrikaans? Do you need an interpreter? Do you need interpreters?
Correct, an interpreter.
Hello?
It is so, I can understand a bit of Afrikaans, but I need interpretation.
Mr. Jonas is here. He will interpret for all of you. Okay. Yes, Mr. Baloy.
As indicated, the witness is witness number 91.
91, right, yeah.
Yeah, on the witness list. Mevrouw Cronje, wat is die van beroep?
Mrs. Just net voor de antwoord gemeente council Qatar. Mrs. Kranye, what is your occupation? Ufuna ukwazi kumshushisi ukuthi umsebenzi awenzayo uyini emagama antwoord.
I'm an ex-Landros.
I am a magistrate, ngiwumantshi.
En bij watter kantoor is u verbonden?
In which office are you attached? Noma yiphi-ke inkantolo osebenza kuyona?
My standplaas is Kempton Park. Huidiglik verrig ek aflosdienste by die Takhof Vosloorus,
My
'n Takhof van Boksburghof.
Okay, kan ons net stadig hou. My office is Kempton Park, but currently I am working on a what is aflos? Yeah. Relief, sorry my lord, as a reliever at Vosloorus Court, which is a branch of Boksburg. Ngisebenza-ke e-Kempton Park kodwa manje la engisiza khona-ke ihhovisi noma inkantolo yase-Vosloorus engaphansi kwayo i-Boksburg.
Wat is die hoofsetel van die Vosloorus Takhof?
Boksburghof.
It's Boksburg Court. The question was which is the main branch of the Vosloorus Court, and it is Boksburg Court. Inkantolo yase-Vosloorus ingaphansi-ke kwayo inkantolo yase-Boksburg.
En hoe lang is u Landros?
How long have you been a magistrate?
Sedert 1996, 1 Julie.
Since the 1st of July 1996. Ukusuka-ke nge-1 zika-July ngo-1996 nguyena umantshi.
My permanente aanstelling het eers 'n jaar later in 1997 deurgekom.
And my permanent appointment only came in a year later, that is now in 1997. Ukuthi ngiqashwe-ke ngokuthi-ke ngisebenzeke noma ngime permanent kweza-ke emuva kwesikhathi esingangonyaka ngo-1997.
Nou, voor u Landros geword het, wat het u gedoen?
Before becoming a magistrate, what were you doing? Ngaphambilini kokuthi-ke ube uyena umantshi yini owawuyenza?
Ek was 'n staatsaanklaer van beroep met ingang van 1 Desember 1990.
Okay, just a minute. In December 1999,
Nee, 1990. 1990.
Yeah, that's correct. I get that. I was a prosecutor starting from the 1st of December 1990. Ngangi umshushisi-ke ngaphambilini kokuthi ngibe nguyena umantshi ngaqala ngo-1 December 1990.
was tot en met 1 Julie toe u as landros aangestel was.
Was that now up until 1 July when you were appointed as a magistrate?
Dis korrek.
That is correct. Yebo ke lokho ke kwaze ngaba uyena ke umshushisi kwaze kwayoshaya ke uJuly noma i1 zika July uma sengi ngithola ke umsebenzi wokuthi ngibe imantshi.
Is it correct that vir die tydperk 1 Julie 96 tot u permanente aanstelling in 97 u was 'n waarnemende landros?
Dis korrek.
Is it correct that from your time of appointment, that is 1 July 1996, up until your permanent appointment in 1997, you were an acting magistrate? Yes, that is correct. Yebo kuyiqiniso ukuthi kusukela ke ngaye ngazo i1 July 1996 kwaze kwaba u1997 ke ngangiwu magistrate kodwa ngasiyena ke umagistrate permanent.
Ek toon aan u 'n dokument wat ingehandig is as bewijslik JJ.
I'm giving you now or showing you a document which has been handed in as Exhibit JJ.
Kan u vir of die dokument identifiseer?
Can you identify the document for the court? Kunale document ke engizokubonisa yona ke esifakiwe noma idlulisiwe enkantolo nanjengesiboniso noma ke Exhibit JJ.
There is the document for u.
Is the document in front of you?
Ek het die oorspronklike dokument voor my. Dit is sonder die dele wat u aangedui het verwyder is en dit is die konfessie wat ek afgeneem het op 24 Junie 2020.
I have the original document in front of me, and it is without the portions that you have already indicated which were scrapped out, and it is a confession that was taken on the 24th of June 2020. Phambi kwami nginale document ke ekuyona ke noma ebizwa ngokuthi ke original futhi ke le ndawo okhulume ngazo lezi ezikhishiwe noma eziqishiwe noma ezisuliwe azikho kulena enginayo lena ke ila biko noma kubizwa ngokuthi ke confession eyathathwa ke nge-24 zika June 2020.
Kan u kortliks vir of die agtergrond gee van die gebeure wat aanleiding gegee het tot die verrigting wat geboekstaaf is in bewijslik JJ?
Can you just briefly give the court a background of what happened or transpired with regards to that which is documented on this exhibit which is JJ? Uma nje kafishane ke usungatshela ke inkantolo ukuthi kwenzekani noma kwenzeka kanjani ke ukuthi ke kubhalwe lokhu okubhaliwe la kule document ephambi kwakho exhibit JJ.
Die kantoorhoof van die Hoofhof in Boksburg, wie ook die senior landros is, mevrou Du Plessis.
Just look. The senior magistrate, who is also the office head of the magistrate in Boksburg, which is Mrs. Du Plessis, oyinhloko ke noma ephethe ke kwinkantolo yona ke leyo eyase Boksburg okuyena unkosikazi noma ke uMrs. Du Plessis, yeah.
Het my op 24 Junie 2020 ongeveer 11:00 die oggend by Vosloorus telefonies gekontak.
Contacted me on the 24th of June 2020 at 11 o'clock in the morning telephonically. Yes, he contacted me telephonically at Boksburg Magistrate Court.
No.
Vosloorus. At Vosloorus Magistrate Court. Okwenzeka ke lana ukuthi loyo ke ophethe khona lapho ke enkantolo yase Vosloorus ekuyena uMrs. Du Plessis ngazo i24 zika June 2020 isikhathi kwaku 11 ekseni wangishayela ucingo. Yeah.
Die dienste verrig te Vosloorus Hof op die betrokke dag.
Did you perform duties at Vosloorus Court on the mentioned date?
Dis korrek.
That is correct. Kuyiqiniso ukuthi ngalelo langa lelo ke ngangisebenza kuyona ke leyo nkantolo leyo eyase Vosloorus.
Ja, ek kan voortgaan.
Sy het my versoek om 'n bekentenis af te neem te Boksburg Hof.
She requested me to take down a confession at Boksburg Court. Wase engicela ke ukuthi ngithathe ke noma ngiyokwenza noma ngiyobhala phansi ke i-confession kwinkantolo yase Boksburg.
Aangesien sy self en van die ander senior landroste wat meer senior in posisie was, nie beskikbaar was om die konfessie af te neem nie weens hulle betrokkenheid na bewering by artikel 205 wat hulle self hanteer het met betrekking tot die aangeleentheid waarvoor ek versoek was om 'n konfessie af te neem.
Reason being that she herself, as well as other senior magistrates who were much senior, were in no position or couldn't be involved or take part in the taking down of the confession, seeing that they were personally involved in the section 205 of the very same matter. Isizathu ke noma imbangela yokuthi angiceleke kwakuwukuthi yena kanye nabanye noma ke ozakwabo ababengaphezulu ke kuyena ngesikhundla noma ababesinya kuyena ke bengakwazi ke noma bengakwazi ukuthi bangayenza the confession lena ngoba ke kwakusekukhona ke ngaphambilini lokho kubizwa ngokuthi ke section 205 okuhlanganisa nalo lecala leli ke ababasebe kwenzile okusho ukuthi ke babengakwazi ukuthi bangaphinde benze okunye okumayelana nalo lolu daba futhi.
Maar dit vir die volgorde van die getuienis, dit sal seker nie veel skade doen as dit op rekord geplaas word.
It is yes, my lord, but as the evidence will be then unfolding or proceeding, I don't think that it would it won't cause that much of damage.
So mevrou Du Plessis het die meegedeel dat hulle gediskwalifiseer is aangesien hulle reeds betrokke was by artikel 205 aansoeke aangaan hierdie aangeleentheid.
So Mrs. Du Plessis informed you, in other words, that they were now being they were disqualified in proceeding or taking down the confession, seeing that they had already been involved in the section 205 of the very same matter.
Dit is korrek.
Sorry.
Yes. I'll actually to raise an objection in relation to this evidence.
Yes.
It amounts to hearsay. Unless Mrs. Du Plessis will be called to testify and confirm the contents thereof.
Was it?